Elon Musk and Sam Altman are locked in an aggressive rivalry to determine which of their companies will lead the development of artificial intelligence. In the tech industry, when market competition reaches a stalemate, the legal system often becomes the next theater of conflict. Over the span of just 4 weeks in 2026, Musk launched a massive two-pronged legal assault targeting OpenAI. This campaign resulted in back-to-back defeats for Musk in federal court. The rejection of these multi-billion-dollar claims by the U.S. legal system highlights the specific evidentiary standards required to challenge the creator of ChatGPT. The first major strike occurred in a federal courtroom in mid-May, focusing on OpenAI's origins. Musk's core argument was that OpenAI and Altman had stolen a charity, alleging they betrayed a nonprofit mission to enrich themselves. The financial stakes were set at $150 billion in potential damages. On May 18th, a federal jury ruled against Musk, finding that the evidence did not support the claim that OpenAI's shift in corporate structure constituted a betrayal of its original mission. Because the jury rejected this ideological challenge to OpenAI's mission, Musk moved to a second front, a technical attack focused on source code. By June, the legal conflict moved to a U.S. district court in San Francisco. Musk's xAI alleged that employees leaving the company had stolen trade secrets in source code related to its Grok chatbot. The accusation centered on a former xAI senior engineer, Shuchen Lee. Judge Rita Lin identified a primary gap in the evidence. xAI failed to show that OpenAI leadership actually induced Lee to divulge confidential information. Secondly, the court found no proof that OpenAI's engineers knew Lee might have shared trade secrets. Judge Lin dismissed the case with prejudice, a ruling that prevents xAI from filing these same claims again. The judge concluded that continuing the lawsuit would be futile given the lack of a factual foundation. This illustrates a strict standard in intellectual property law. Suspicion of theft is not a substitute for forensic proof. In less than a month, Musk's attempts to prove both ideological betrayal and technical theft had been dismissed by the courts. These rulings set a precedent for the broader industry, where companies compete fiercely for a limited pool of AI talent. The court confirmed that losing an employee to a competitor is not as same as losing intellectual property. For any future trade secret disputes, companies will be required to present specific, documented proof of corporate espionage. By setting this high evidence bar, courts ensure companies cannot use litigation threats to prevent the movement of skilled engineers between rivals.